You've known Robert before from years in the past, and Robert is a South Carolina firearms law attorney, and he does as well some other things. He used to be an attorney for a defense contractor, and he also is a contributor to the NFA portion of the book. He's originally from the Low Country and a graduate of Wofford College with dual degrees in computer science, business economics, and he received his JD from Washington and Lee University School of Law. So thank you for presenting, Robert. It'll be a half hour.
Steve, thank you. I guess this is the joy of lunch. I get half a house. We're going to talk about firearm rights restoration. To do that, we'll start at the beginning with how you lose your rights, because how you lose them affect how you get them restored. And then we're going to get into the real interesting twist is what restoration in this state, what effect does it have on your rights in another state? So we'll actually be using the word reciprocity. Most of you all will be familiar with that in the terms of a CWP, a concealed weapons permit. Do you have reciprocity to carry your firearm in another state? Well, for someone who has lost their rights, the question now becomes, do they have reciprocity on restoration just to have a gun in another state? So how do you lose your rights? There's multiple ways in South Carolina. We've heard a lot this morning about criminal domestic violence. So you can see that down there is the fourth bullet point. At the top we have a violent crime prohibition on handguns. Historically in South Carolina it was the only way you could lose your gun rights by state action was a very limited loss on handguns. Recently we've enacted a violent crime prohibition on firearms in general. So both of those look similar, but their definition of violent crime is slightly different. And then finally we have a mental prohibition for somebody who is adjudicated incompetent. So let's walk through these in some detail. We'll start with the handgun possession. It's the oldest one that we have. So we got persons who are convicted of a crime of violence in any court of the United States, the Commonwealths, the Territories, District of Columbia. So that's very clearly stated, all courts. We got a situation where if you're convicted in North Carolina, you're going to lose your handguns here in South Carolina. We got clear, keep that in mind. People fugitive from justice, habitual drunkards, drug addicts. The list continues on with what you would expect from the 1968 Gun Control Act. Mentally incompetent, subversive organizations, minors under the age of 18. You'd age out of that one. And then certain orders of the circuit in the courts. Now we're going to juxtapose this with the prohibition on possessing all firearms. I got a long list up there. I don't expect you all to read that. It's in your handouts. I imagine most of you all have a hard time reading it. I wouldn't be able to read it from the back of the room. That is a list of statutes that the legislature considers to be violent crimes. If you're convicted of one of these, then you lose your gun rights. What is interesting to note is that the law does not state that what court are you convicted in. It doesn't come in there and say you have to be convicted in a South Carolina court, nor does it say that you could be convicted in another court. It says if you are convicted of a violent crime as defined in, and it gives this list, then you lose your rights. So we have an interesting situation where we could make a good faith argument that even though you were convicted of doing one of these acts in another state, it wasn't this act, it wasn't this statute you violated. That's going to be an interesting question for a judge one day to handle as to whether the prohibition under 1623-500 covers convictions in other states. It does not clearly state that, and I think there's a good argument to make that it would not. That will become important as we move on. So criminal domestic violence, I'm not going to harbor on this one too long. I think Henry's been hitting it pretty well. It's a tiered system. You got 3 years, 10 years, lost for life. And it applies again to crimes containing the same elements committed in another U.S. jurisdiction. So again, juxtapose that to the prior two ways you lose your firearms. Two of them tell you any jurisdiction conviction counts. One just says if you're convicted of these set crimes, all of them South Carolina statutes, you lose your rights. Mental defectives. If you're adjudicated as mentally incompetent, that basically means you're going to be sent to an institution, you can't take care of your own finances, something of that nature. That's going in front of a probate court. That's the probate court hearing on your person deciding for you. Voluntary, if you show up there yourself and go for treatment, that doesn't count. So this is another way that you can lose your rights. And notice this would line back up with the loss of rights that you would have under 1623-50, because for the handgun prohibition, if you are mentally incompetent there, you've also lost your handgun. So these two work together in a way. Now, we're not interested in just how you lose your rights in South Carolina, but also how you lose them federally, because that's going to affect us here too. So the federal law is going to look a lot like that first one we viewed, where if you meet these criteria, fugitive from justice, illegal alien in this case is one we hadn't seen earlier. There's the mental institution part showing up. These things lose you your rights. We also still have drug addicts, habitual drunkards may or may not show up in that list if we consider alcohol a controlled substance of some sort. And then convicted in a court of a crime punishable by imprisonment for a term exceeding 1 year. If you look at the definition of a crime punishable by a term exceeding 1 year, for a misdemeanor it's actually a crime exceeding a punishment by 2 years. So felony charges all count, and then misdemeanors greater than 2 years count. That's a worthwhile thing to note in South Carolina, because we still have a fair number of misdemeanors that have been around for a long time. They have a 3-year sentence possibility. So those would lose your rights under the federal standard. There's some other people that are prohibited from having rights in the federal. It's aliens admitted to the United States, non-immigrant visa. So if you're not a permanent resident here, not a green card holder, you don't get gun rights. The Constitution is not considered to be attached to you. Dishonorably discharged. So if you get to come out of the military with a bad record, you lose your rights. Renounce your citizenship. Which, renouncing your citizenship is just not standing up and saying, I'm not a citizen. There is actually a procedure. You hand a passport over at a consul in a foreign country. So if you go through that long, lengthy procedure, you're going to lose your gun rights. Subject to a protective order. Henry was hitting those very well. I'll leave that with his presentation. And then any court misdemeanor crime of domestic violence. As Henry pointed out on that is not actually defined as a crime of domestic violence. It's defined as, committing an act of violence against someone with a set relation to you, or against someone that has a relation with a relation to you. So a crime against a child of your live-in girlfriend, even though it's not your child, would count. So you wind up with a situation where some misdemeanors, assaults and batteries and so forth, are going to count under the federal standard for criminal domestic violence. They're not going to count under the state standard. So you wind up losing your rights at the federal level, but not at the state level. That is an interesting thing to note, because you can't own a gun. But if, and Mike's disappears, I can't pick on him. If the sheriff of Pickett County, Charleston County, comes in and says, or arresting you, the sheriff cannot charge you with the federal crime. He can recommend it to the ATF, he can recommend it to the federal agencies to charge you with that crime, but he can't bring it. And if we don't have a similar law in the states, then you're not going to have that charge from the state. So that is worth noting, that your person can fall into a gray area where the feds may not really care to do much about it, and the state really can't do anything about it. So let's talk about restoring those rights. Rule of thumb, seek redress where you lost the rights. So when somebody comes to you and says, I want to restore my rights, the first question is, where did you lose them and how? What court, state, federal, what county, what city? Now there is another alternative. We've hit on it today already. There is a provision in the law that you can go to the ATF and get a special restoration of your firearm rights. It's not funded. It hasn't been funded for 2 decades now. There's maybe hope that changes, but right now if you have a client come to you and says, but I found it in the statute where I can get my rights back, it's good for you to know the exception. And that's the exception is there's no money to do it with. So let's talk about restoring your rights in South Carolina. There are basically 4 options. And one of these is going to be the largest of them, that's the pardon. But we have expungements, pardons, automatic restorations in some CDV cases. Now, Henry talked about it. We let y'all know there's a tiered system, 3 years, 10 years life. If you're in one of those 3 or 10 year systems, then after that time passes, you can get some automatic restorations. And the court proceedings. So talk about expungements. Expungements are going to be of limited availability. Therefore, thank you all for letting me know. And I'm not sure if it's coming back. Can you hear me now? Still no. Right, there we go, okay. Adapt and conquer. All right, so for expungements, they're going to be limited of use because not many misdemeanors are going to actually cause you to lose your rights. Expungements in South Carolina only for misdemeanors, first offenses. So if you've committed a CDV and before the time comes for you to expunge it, that's a 5 years you must wait before you can expunge a CDV. And during that next 5 years you get arrested and convicted of publicly disorderly conduct, you're not going to be able to get an expungement. But if it's your only event and 5 years pass, you then can get an expungement. So I mentioned earlier when Henry was up here about you try to plead down to assault and battery, but you're still going to have the problem with the ATF saying, who did you assault and batter? It was your wife. You're going to fall into the federal trap and you cannot possess a gun. Small win. Because assault and battery is not CDV, you have only a 3-year requirement before you can get your expungement. So you can knock off 2 years of that prohibition if the person wants to wait and get their expungement from that direction. So there is still a small win on negotiating it down. I say it's fast but expensive compared to pardons. Everything's relative. You know, applying for pardons just a little bit over $100, you're going to burn a little bit over $300 applying for an expungement. The biggest thing is your pardon's probably going to take around 9-10 months. Your expungement's going to take 2 to 3, depending on the county and the circuit court and so forth. This would be your preferred method of getting your rights restored. Will become a little clearer as we discuss how other states recognize restorations. The great thing about an expungement is it's not only forgiven. You're not only going to be given your rights back, the state's going to forget. They're going to get rid of that record, bury it at SLED. They do keep it for SLED because you only get to use it one time, and if you've used it once, they need to know how you used it to make sure you don't use it twice. Reasonable. So it's buried at SLED, but other states aren't necessarily going to get action to it. Standard law enforcement is not necessarily going to get access to it. So if you're asked, have I been convicted of a crime? With an expungement, you can say no. And if it's been done correctly, they're not going to find you have ever had something of that nature happen to you. So if you can get your client an expungement, that's the absolute best way to wipe this off the record. For the vast number of crimes, though, expungement's not available. All your felonies fall in this category, and somebody who commits 2 misdemeanors falls in this category. This is your pardons. Now, this is available to everyone. You go to in front of a pardon and parole board, you make your case, you present your character witnesses, they consider it, and they get your decision right then and there. But right then and there, it takes 9 months to get to. The pardon is forgiveness. It's still on your record. Somebody asks if you've been convicted of a crime, you're still going to answer yes. If you get a background check on you, they're still going to see it. They may see it's pardoned. So if you go to another state, that conviction still exists. That's a key thing to think about here as we move forward. Now, our pardons in South Carolina State, they restore all civil rights and then include, and they give a long laundry list of things such as voting, right to serve on a jury, etc. It does not in that laundry list say firearm rights. So we wound up with a case to this matter. A gentleman wanted to get a pistol. SLED had denied him at a time when they were still doing some permits and issuings, and he brought suit. The courts came back and said that the law states all rights are restored. The legislature has shown that they know the pardon restores all rights and they know how to exempt things from that. There is a particular case that a statute I should say, that exempts from the forgiveness of pardons the requirement to register as a violent sex offender. So the sex offender list, even if you get pardoned, you're still registering. That showed the court that the legislature knew how to make an exemption in the pardon. They didn't do that for firearm rights, so they determined that firearm rights are restored. Now, in looking through all this, I came up with a little interesting twist, which is a moot question, but we'll address it. In 1625-30, we have the prohibition on people who commit criminal domestic violence. That prohibition is staggered, 3 years, 10 years, life. Nowhere else in our laws do we actually prohibit somebody from owning a gun for life. So now the question becomes an interesting one is, would that wording for life somehow be an exemption to the pardon? I wouldn't think so, but just to make it clear, the legislature did put in there 2530C saying that expungements and pardons don't count. So, meaning that if the conviction has been expunged or the conviction has been pardoned, it doesn't count for this provision. So the legislature answered their own question, and if you do get the pardon, expungement within that statute is not going to count. So what we can see, that's something I'm going to point out, when you lose your rights by criminal domestic violence, within the statutes, a conviction that has been expunged or pardoned does not count. When you lose your rights by 1623-500, that says you've lost them by committing one of these violent felonies, all of which are South Carolina statutes. They don't have to say whether or not that conviction's been pardoned because they already know by case law that pardon is going to give you those rights back. And if you only can lose those rights by committing the crime in South Carolina, there's nothing to address there. However, in 1623-50, in the case on, or the statute on handguns, it very clearly says that convictions of offenses in other states lose you your rights. And there's no exemption, there's no exception about whether those convictions have been expunged or pardoned. So South Carolina does not say that if you were convicted in Virginia and Virginia pardons you, that we're going to recognize that pardon. That's going to become an interesting question as we look at what some other states have done, case law-wise. So we're going to talk about what happens when you get your rights. Well, this is automatic restoration. Let's touch this real quick. There's actually a provision that in the CDV, after the 3-year, 10-year, your rights are supposed to come back. You can call SLED, you can write SLED, SLED should write NICS, you should get your gun rights back. That's fairly straightforward. There's no going to a court, there's no petitioning, there's no fee to it. It's a minor inconvenience, if you will. For the mental defectives, you have to go back to the probate court that took away your rights, the court that committed you. You have to present to them character witnesses, and you're going to have to tell them that you're a good person. One of those requirements is having a psychiatrist give an evaluation and say that you are not likely to cause harm more than an average person. They don't have to come in and say you're not likely to cause harm. The standard is you're not more likely to cause harm than the average person in this room. And that is a tough standard to find a psychiatrist to understand. Most of them are looking for what liability they're going to have if a person they say is good commits a crime. Now when you do the hearing, your relief's going to be granted if you meet the 3-prong test here. No longer subject to court-ordered treatment. That's an easy one to know. The court gives you a length of treatment. Once that expires, you can now seek your rights back. A psychiatrist gives you determination that you are not likely to act in a manner dangerous, and the court finds that relief is not contrary to the public interest. So again, we're looking here is this person going to be a danger to the public more so than anybody else? And if the answer is that is no, he's in the same category as the average person, then you'd get your rights restored. Well, let's talk about reciprocity. This is the part that makes this interesting. The federal government has its own definitions of conviction. They have their own examples of expungements and pardons and so forth. Aren't counted as convictions. That pardon is that forgiveness. So if the state where you are convicted in says that you are forgiven, then the federal government's going to believe that you're forgiven. So they got two parts of that, the NICS Improvement Act and then 18 U.S.C. 921. And basically, if the place that took your rights away give them back to you, we recognize them. The instructions to the Attorney Generals is a very broad one, telling them be as lenient as you can on this. If they've had expungements, if they had pardons, if they went through a petition, had their gun rights restored, if they had their civil rights restored generally, as long as they didn't have an individual finding in the restoration that said you do not get gun rights back. So if you had to go to the court and the court says we give you all your rights back but we still think you're dangerous and you can't have guns, that would not be counted. But if the court just says, yeah, you get your rights back, don't ask what the details are, that counts. So I refer to that as salvation. You're forgiven by one, the federal government's going to forgive you. That would be the exact same standard that we have for criminal domestic violence cases, because we don't count convictions that have been expunged or pardoned. But not everybody believes in salvation. Some people believe you have to pay your time, and they believe in purgatory. So I'm defining that refusal to automatically recognize that restoration. That's the government saying, okay, we know that South Carolina gave you your gun rights back, but we're not necessarily going to recognize that. You have to do something else. I'm going to pick one on northern state. North Carolina has a provision that if you've had your rights, civil rights, non-firearms, restored for 20 years, and you've been a good person those 20 years, you can then go back and get your gun rights restored. It's through a petition process. So they're not using a pardon, they're not using expungement. Well, if you've had your rights restored by petition in another state, as long as you've been a good person for 20 years after that, you can get your rights restored through a petition in North Carolina. So they're going to treat us equally from that standpoint. But you still have to go through the process in North Carolina. Now that's talking about getting your rights restored by a non-pardon, non-expungement provision. For example, I know we've got attorneys in here from Virginia. Virginia has a petition. The governor gives you your rights back, but to get your gun rights, those gun rights are exempted from what the governor can give you. You have to go in front of a court, you have to petition to get those rights back. It's not a pardon. You're not being forgiven of the crime, you're just getting rights back. North Carolina's not going to recognize that. You're going to have to go back through their system to get recognition. Now, there is a small exception in the North Carolina law saying they're not going to count pardons if you could have gotten those rights restored in the same way under North Carolina law. That creates an interesting question for us in South Carolina, because if we have a client convicted of a crime in South Carolina, lost his gun rights, we get him a pardon. Does that pardon and that exemption override the direct provisions that North Carolina provides for getting your rights restored? And that question is really going to come down to, one, on the crime itself, and seeing if such firearm rights could have been restored in North Carolina by that. So we're actually going to see that addressed in another state. Any Tennessee fans here? Good. I pick on Tennessee for eternal damnation because they took a view in the case there, Blackwell versus Haslam. The gentleman here had a conviction in Georgia, drug offense. He got a pardon in Georgia. He wanted to own guns in Tennessee. So he brought case to declaratory judgment in Tennessee asking to get his gun rights recognized. He had them restored in Georgia. It went up to the appeals court, and the appeals court said, in Tennessee we don't believe violent felonies get their gun rights restored, ever. That's a public policy exception to the full faith and credit clause, so we don't have to recognize what Georgia does. But we can give our gun rights back to somebody who didn't commit a violent felony. And because that's not a public policy difference with Georgia, we'll recognize that pardon. And we don't know whether this drug offense was violent or non-violent, so lower court, you go figure that out. The short here is, if you commit a violent offense in another state, even if you get pardoned in that state, Tennessee's not going to give you your gun rights back. You've lost them forevermore. Because a conviction, even though pardoned, is still technically a conviction. Which that goes now back to our law on handguns. Prohibition for handguns, remember, says convictions in other states. But doesn't define the term conviction. There's nothing in conviction about whether or not a pardon or expungement is going to exempt it. We know that our state can pardon, but we don't know what effect the other states would have. And just to make the point about how much Tennessee doesn't care, a presidential pardon, they're not going to give you anything on that either. So, yeah, if you're in Tennessee, even a presidential pardon is not going to get you your gun rights back. And the same is going to hold true in Virginia. The case here, we had a gentleman from West Virginia, lost his rights, got him restored in West Virginia. He came back into Virginia. They picked him up with a gun, and they said, you were convicted, therefore you fall under Virginia statutes that says a convicted person cannot have a firearm. He goes, wait a minute, I've been forgiven, I've had my rights restored. And they said, sorry, you didn't have them restored in Virginia. You might be able to own that gun in West Virginia, but you can't own it here, and they sent him to jail. So this isn't just a theoretical people being overly cautious and going back to the state and saying, my rights restored. We do have people serving jail time because they didn't understand that a forgiveness in one state didn't mean they got their rights restored in another. So if you have a client come to you and say, I want to get my rights restored, I lost them in another state, you be careful. Make sure that he can have them in South Carolina based off what that crime was and how he gets them restored. And if he gets them restored here and says, great, I'm going to North Dakota to go pheasant hunting, he may not be able to take that gun there. Or if he can hunt in North Dakota, he might not be able to carry it through other states to get to it. So that's things you have to think about advising clients who are getting a gun rights restoration. So to summarize it up, always look at where you lost your rights. That's the first place you got to start, is how do you lose them? That's how you start for restoring them. Some states may require additional steps even though they weren't lost in that state. Virginia falls in that category, North Carolina falls in that category. How you're going about restoring them depends on how you lost them. Expungement, always the best, but you don't have to resort to pardons a lot of times in South Carolina. Sometimes you can get a fellow on a CDV off relatively simply with the letter, as those start to come up, the 3 years and 10 years prohibitions. And mental incompetency is going to be probably one of the more lengthy ones with an actual hearing and so forth, though those hearings have to take place in 90 days unless you ask otherwise, so it's still fairly fast. And then for recognition, it's a state by state. It may be clear, it may not be clear. You have to look at each state. And if you've ever been convicted, if you ever lost your firearm rights, even though you've had them restored, it's still not advisable to travel interstate armed. Just because there is such a patchwork, even worse than the reciprocity, and most people aren't even thinking about it. Anybody have any questions, or we're all in a food coma?
I got a question.
Yes, sir.
Years ago, the divorces, when we had the 3-year separation, now it's down, I think, 1 year. A lot of divorces were based on physical use of alcohol. So, habitual drunkard, Otis Campbell here, how long does that last? In other words, can they get a gun in South Carolina? Can they hold a gun?
There's no provision in South Carolina state law. So there's nothing that says that it's a 1 year, 2 year. Now, habitual drunkard is a state, it seems, that can change, and federal law, not specifically, but in the application has recognized that if you're arrested on drugs, or if you're, have something of drunkenness come up, that they go for 1 year. They look at it and say, okay, if you got arrested with illegal drugs, even though we didn't convict you, we're going to call you a habitual user for the next year. In that case, you might have to try to do a finding. You may tell your client, well, you can't own a handgun, but nothing about South Carolina says you can't own a rifle or a shotgun, so just stay away from handguns. I hope that's a question that we'll be phasing out since the divorce laws have changed.
Sounds good, Robert. Why don't we take a 5-minute break here, and we'll be back.
Thank you all.